So what I've been asked to talk about are some child labor issues, and then I'm going to talk a little bit about two state-level immigration issues that are beginning to develop. As we go into every legislative session, I'm always paranoid about state-level immigration issues coming up, and it seems that there are a couple that may surface during the session. So I'll brief you on those two things, those being dealing with the state E-Verify law and then a restricted driver's permit bill. So let's start with child labor. I know a lot of you may have questions about what our child labor laws are, and my goal here is to give you just a rough outline of what the law says with respect to child labor, and then if you have any questions, we can do our best to answer them. But as you all know, there are several, let's start here. Federal law governs child labor, and there is a tiered system by age that governs what a child laborer can do, and it sets up basically a good structure for you to understand on your farm how you can employ children who are under 18. That's what we're talking about. And there are rules for agriculture, and there are rules for non-agricultural jobs. As a general rule, the non-agricultural jobs are 2 years higher than in age than the agricultural jobs. So what do I mean by that? To work in a non-agricultural job, you have to be 18 or over to just do anything that the employer asks you to do. Let's say you're working at a quarry and you're doing mining stuff and they want you to drive a tractor. If you're above 18 years old, you can do anything on that operation. On an agricultural operation, the age is 16 and above. So you can employ anybody who's 16 and above, and you can give them any job that they have to do for an unlimited number of hours. And there are different job classifications. There's hazardous jobs and non-hazardous jobs, and we'll get into that in a second. The second tier are minors who are 15 to 14. And minors who are 15 to 14 can perform any non-hazardous job outside of school hours. So the school hours, there are no limitations on anybody above 16 in agriculture. But for agriculture, non-hazardous jobs outside of school hours. But if you are the parent of that child, that rule doesn't apply to you. You can just work them as much as you want because they're your own child. And then children who are between 13 and 12 may perform non-hazardous jobs on a farm with parental consent or if the parent is working on the farm. And I think that's the one that gets us in a little bit of trouble sometimes if people see kids working and they're parents and they may not understand that law. But that's the 13 to 12. And then there are some limited situations where you can work children under 12, and we don't need to get into all the details there. But that's what the law says at the federal level, and that is in statute, which means that Congress has to enact a law to change that structure. Now, determining what a non-hazardous job is versus a hazardous job, that's a Department of Labor determination. And so you can see that come up through rulemaking, and you all will recall, what was it, 2011, we had the Obama administration's Department of Labor rules that American Farm Bureau helped us beat back. So that's your basic structure. Now, as a matter of federal law or as a matter of state law, the federal law sets the floor for the states. And so states can always enact laws, or typically can enact laws that are more restrictive than the federal law. And so there is a possibility that the North Carolina General Assembly could then say, you know what, we don't want anybody under 16 working in agriculture at all. Even though the federal law is what it is, we're going to impose our own law. Now, North Carolina conforms to the federal law. So we just follow federal law in North Carolina. But there have been bills filed in the past that would prohibit anybody under 14, with the exception of family members, from working in agriculture. There was a bill filed during the 2013-14 General Assembly session by Floyd McKissick, one of our good buddies from Durham, who introduced that bill. I haven't talked to Senator McKissick about this issue during this session. I don't know if he's going to file that bill or not. But given all the Human Rights Watch groups that are out there and all the child labor advocate groups that publish their reports about labor and agriculture, I wouldn't be surprised if there's a bill filed. As the year goes along and we get further along in the growing season, you may see a bill or two or some issues or discussions about it. So I just always keep that in the back of my mind. But that's the general overview of what our child labor law is. Do you guys have any questions about that?
I do.
Yeah.
If you have all H-2A workers and they are supposed to be 18 or over to be brought in, and a 16-year-old calls and wants to work, what do you do?
Wow, Pat. I don't know.
What I did. Maybe I should say that.
Yeah, tell me what you did.
I said that I couldn't because my requirements were to have workers that are 18 and over because it's specified by the H-2A.
Yeah, there's nothing that would prohibit you from hiring the 16-year-old under North Carolina law and federal law, but the H-2 situation where you have to treat the H-2s the same way you treat everybody else may be a...
So
Craig?
That was what I did, but kind of...
My good friend Craig Regenberger may have an answer.
Well, I just have an anecdote, which is we had somebody in my industry in Ohio who's an H-2A employer, and they hired a couple of able-bodied high school kids older than 16 to give them some on-the-farm experience. And when they had a wage and hour audit, they had not paid these individuals the adverse effect wage rate. They were found to be in corresponding employment, and so they had to pay back wages and penalties and everything else. So the H-2A complications will bear out if they're doing anything in common with their H-2A workers. Yeah. Any task at all in common will be found to be in corresponding employment. So you can't give a break to give experience. You've got to pay them the adverse effect wage rate.
I would wonder about them being local, where you're obligated to work local people over the H-2As anyways, if that would come into play.
Yeah, I don't know.
I mean, that's just something I would wonder.
The question was whether you, because they're local workers, do you have an obligation to hire them under the, filling those U.S. jobs first?
Well, I had a little backup with experience laws.
Gotcha. So, are there other questions about the child labor issue? All right, let's talk about the other two state legislative issues. On E-Verify, you will recall that in 2012, the General Assembly imposed an E-Verify mandate on North Carolina businesses. And that law said North Carolina employers who had more than 25 employees must use E-Verify for all new hires, and they put in a seasonal worker exemption that said if your employee works less than 100, I think it was 180 days, they don't count. You don't have to E-Verify them. Well, that seasonal worker exemption didn't work because the E-Verify rules, when you sign your memorandum of understanding with the Department of Homeland Security to use E-Verify, you can't discriminate between workers. And the way the state law was drafted, it said you just don't even have to E-Verify the seasonal workers, which puts you in conflict with the memorandum of understanding that you signed. So we asked the General Assembly to fix that law, and our now good buddy Harry Warren, who's a Republican member from Rowan County, introduced a bill called the Reclaim NC Act that gave us some relief on the E-Verify mandate. And what the law, I won't take you through all the history of it, but what the law says now is if you have an employee who works less than 9 months in a year, you don't have to count them when you're figuring out whether you have 25 employees. So how does that work? Let's say I have 20 full-time employees on my farm, and then I hire 10 seasonal workers who work 8 months during the year. For purposes of the E-Verify law, I only have 20 employees because I don't have to count my seasonal workers. So I don't have to use E-Verify. That's the way the law works. We were really pleased to get that done. We had to override Governor McCrory's veto to get that done. It's the first time we've ever done that. So Paula got a nice scalp on her way out the door in 2013 or 2012. Sorry, 2013. So now, I had a conversation about 3 weeks ago with George Cleveland, who is a Republican from Onslow County. And Representative Cleveland told me I'm going to refile my bill to impose E-Verify on all businesses in the state because he just doesn't like the 9-month seasonal worker exemption. He said, but I'm going to exempt agriculture because I don't want you guys beating me up all about it. And then he looks at me and he goes on to this rant about how illegal immigration is horrible and immigrants are costing our society, et cetera, et cetera, et cetera. And then he says, have a great day. Thank you, Representative Cleveland. So I presume he will file his bill. We have taken steps with communicating to our House leadership friends that we just wouldn't like that bill to come up at all. So we'll see if they listen to our plea. But that bill will probably be filed. I don't have any indication that the Senate, the state Senate, is going to do anything on E-Verify. They tend to be a little bit less eager to do state-level immigration stuff. Finally, Representative Harry Warren, our friend who helped us fix our E-Verify problem, when he introduced that bill, the Reclaim NC Act, it had two major components. One was the E-Verify fix. The other was a restricted driver's permit. And the way the bill worked, or the way the law would have worked if it had passed, would have been, it would have required an undocumented individual, it would have allowed them to get a restricted driver's permit, just an ability to drive a vehicle on North Carolina highways. You can't use the permit as an ID to get on a plane or to enter a courthouse, a federal courthouse, anything like that. It's just a straight driving privilege. And what an employee or what a person would have to do is go into the DMV office, declare that they're in an undocumented status, pay the fees to get the license, pass the background check, or pass a criminal background check, pass the driving test, and have insurance. The idea behind the bill was to be a public safety, highway safety measure. We strongly supported that. As the bill was moving along and it got to the House floor, a lot of Representative Warren's colleagues just said they couldn't go along with that. And so what they decided to do was take that part of the bill out and just move forward with the E-Verify part. Representative Warren wants to get back at that restricted driver's permit, and so he indicated to me and Paul Sherman yesterday that he's going to try to refile his bill. So as I joked to President Wooten yesterday, we got a new priority issue on our plate, and we'll do our best to try to get that across the line if it comes up. We'll need your help. We'll need your help with your members in the General Assembly, especially the State House, to do an education effort about why it's important for these folks to have that limited driver's permit, not only for them to get to work and be able to move around the state, but to have the public safety aspect of it. The idea goes, if a law enforcement officer sees that they have this restricted driver's permit, they know the person's passed a background check, and there will be a stay basically on any kind of immigration enforcement on that individual from a state perspective. No, I don't. Typically. Now, I can't make any guarantees, but they tend to be more open to that type of stuff. Senator Brent Jackson and Tom Apodaca from Henderson County are both pretty open to our views on that issue. So, but we'll see how it shakes out. But I wanted to let you know about that. Those are two developing issues that have happened in the last couple of weeks. Going into the session, I didn't think state level immigration stuff would pop up, but we may see it, we may not. Harry's got to count some noses and make sure he's got enough votes to move it. Hey, Johnny.
Did I understand that Farm Bureau is going to oppose the representative bill from Onslow County to exempt agriculture?
No, if his bill started to move, we wouldn't oppose his bill if it really gets legs. We don't love the idea, because the E-Verify law currently applies to everybody. So if it doesn't impact us, we'll just go, okay. But the other industries that supported that bill will have a problem with it. We just ask people not to change the state E-Verify law at all, because we went through a period where 2011 you had the proposal, 2012 it went into effect, 2013 we overrode a governor's veto to get the 9-month exemption, and that's a lot of uncertainty with respect to the E-Verify law. So we're just telling them, just don't mess with it at all. But we're not, if the bill started moving and it had legs and he could get it going, heck no, I wouldn't tell him we're opposed to it.
Is there a federal E-Verify legislation now?
Yes. Linda, have y'all talked about that?
Does it supersede North Carolina?
Yes, it would. If it was the current E-Verify law is voluntary, and that's one of the.
Just for your clarification, we discussed but Judiciary Committee.
Right.
With a mandatory E-Verify on everybody.
Right. And that would supersede North Carolina's law because it would be the federal government saying you have to use E-Verify. That's
That's what's being proposed now.
correct in Washington.
Right.
Yeah.
So,
Probably worth mentioning one other piece. I mean, E-Verify at the federal level is required for certain
Federal contracts. Yep.
There is a broad-based exemption, which we collectively fought hard to get. It's called the commercial off-the-shelf exemption. So agricultural products moving in commerce, like into the school programs
Yep.
and military commissaries, are exempt
Yep.
from that federal contracting requirement. There's also, I think, dollar thresholds. But an important point here is that sometimes states that mandate E-Verify actually try to mandate that the program be used in ways that the federal law does not allow.
Right.
And that's where Jake, I think, was going to
Yep.
supersede.
Yep. Yeah, if the federal government tells you you have to do it, you have to do it. But what's the current state of the law is E-Verify is voluntary for most employers, and so, but the state of North Carolina has said it will be mandatory for people who have more than 25 employees. And so that's why the law applies in North Carolina. Other questions? Linda's giving me a thumbs up. Thanks very much. I'll be around to answer questions later, but good to see all of you.